If you are an independent contractor, you still may have some protection, but there are going to be different benefits you're entitled to as an employee versus an independent contractor. So at the very front end of class, we have to distinguish what is the main difference between an independent contractor and an employee. Now, the IRS says that if the employer or the party acting as the employer can control the quality of the other party's work, then chances are there is an employment relationship. Control the quality of that person's work. Now, you may have heard different things, maybe on television or even on radio, about the differences between an independent contractor and an employee. And many times people say, well, Mr. Silverman, isn't it true that an independent contractor takes care of their own taxes on a 1099 and an employee gets a W-2? Well, that's true. There are some indices of employment status, or there are some ways that you can define the employee relationship by taking a look at some evidentiary issues. All right? So let's say that one party is a contractor, right? And they're not entitled to compensation or benefits under even California employment law. Well, what are some of the indices of that relationship? Well, one question we ask is, does this contractor supply their own tools of trade? So if I own a company that cleans swimming pools and I come to different houses during the day, I pretty much show up whenever I want to, according to my schedule, and I bring my own pumps and my own filters, my own cleaners, chances are I'm a contractor, all right? This seems like it's my own business. If I'm a contractor, I'm pretty much running a business and I have many clients. And I probably answer to many clients, but I don't answer to just one employer. So that's one indicia, or one piece of evidence that somebody could be an employee, or rather an independent contractor. Now, if I'm told what time to come to work every day, and I'm told I have to sit in that chair, and I have my lunch break at 12, and my morning break at 10:30, and I leave at 4 o'clock, and I need to be at my desk at all other times, chances are one party is exhibiting control or exercising control over the other party. And it sounds more like an employer-employment relationship. The payment of taxes is just one issue. Tools of trade is another. But again, back to the IRS definition, you have to know this, that the question becomes, to what extent can one party control the quality of work of the other party? Does that make sense? Is everybody clear on that definition? You have to understand that definition before we can move forward. So if it's unclear, let me know right now. Is there a hand? Just stretching? Okay. So if we, yeah, question.
Could you repeat it, please?
Yeah, sure. To determine whether or not there is an employment relationship, we ask a question, and the IRS will ask the same question: to what extent can one party control the quality of the other party's work? And actually, to what extent can I control what time you come to work, where you're sitting, what time you can take your breaks, when you get vacation, things like that. Perry?
Couldn't an independent contractor do that, though? Wouldn't they have some employees under them? And that's when you would see the
Sure.
relationship?
So an independent contractor can have their own employees. We see that a lot even in the construction trade. You might have a subcontractor who's a masonry contractor, and they have hod carriers or a variety of different people working under them. So they very well could employ people.
So that's the employee relationship you're talking about?
Correct. So that subcontractor could have employees working for them, but that contractor has a contractual relationship with the general contractor. And the general contractor on a job site might have many different vendors or subcontractors working for them in a contractual relationship. but that's not an employer-employee relationship. It's a bit different. So again, the employment benefits only kick in if we truly have an employee and not an independent contractor. Now, in California and in most states, we have something called at-will employment. At-will employment says that an employee can be fired or terminated for any reason at any time as long as it's non-discriminatory. Now, the interesting background of this legislation was that corporate America tried to convince Congress, at least here in California, that this is also a benefit to the employee. And the argument was something like, well, here, even though the employer doesn't have to give notice to the employee if they want to terminate them, it goes both ways. And now, in California, under the at-will employment statute, employees don't have to give notice either, which is kind of a fictional justification in a way, because most employees that want to get hired again probably want to be in good stead with their former employer, and they want to get a good channel of recommendation, so they're probably not going to burn the bridge, and they're probably going to give 2 weeks' notice anyhow. So I say it's somewhat fictitious that the at-will employment law really benefits employers, because again, if Perry comes to work one day and I say, you know what, Perry, you're no longer needed here, please take your stuff, I'm going to have the security guard escort you out. It could actually be humiliating, and we just don't need your services anymore, and I don't have to give her a reason. Now, it makes good sense to have some kind of reason in case she sues me, but she's probably not going to have too much power or too many legal rights to sue me if she's in fact an at-will employee. I can let her go at any time for any reason as long as it's non-discriminatory. Now, there are certain caveats and exceptions. As you can expect from day one, every time we've looked at a legal precedent or a statute, there's going to be some kind of exception. So here the exceptions are, number one, if the employee is a member of a collective bargaining agreement, then they probably have more rights. And that employer has to go through a grievance procedure and hearing procedures before that employee can be terminated. And they may have many chances for probation, and they may have many chances for corrective action before they're actually terminated. As a member of a collective bargaining agreement, employees who are belonging to unions have more rights than non-union employees. All right? So that's one exception to the at-will employment statute. The other exception, and I don't know who would do this, but it still happens, some employees have been granted written contracts of employment. I guess if you're just a stellar employee and there's a lot of competition for you, and I hope that happens to all of you, if you're in demand as an employee and the employer wants to enter into a written agreement of employment with you, then good for you. If it specifies 2 years employment, right, if I want to hire Perry back to my company and I give her a 2-year contract, and even if I terminate her, I'm still on the hook to pay her for those 2 years, right? So if I'm counseling most employers, I tell them to stay away from the written contract unless you have an employee who may be taken by another company, right? If they're in demand, then you have to give a written employment contract because this person is negotiating with many different other companies to get a job. Okay? Any questions so far on at-will employment and the exceptions? Tell me your name, please.
Ruth? So the at-will employment, you know how you said it's in California, right?
I'm sorry?
It's in California.
At-will employment is in California. Most states have at-will employment.
Is it all employees that are like that? Or
So all employees are at will unless they're members of a collective bargaining agreement, they're members of a union, or they have a written contract specifying a term specific for that employment. Otherwise, everybody else is at will employment. If you work at Chuck E. Cheese as a server, you're probably an at will employee, and you can be terminated at any time. Now remember, the caveat again to that is that you can't be terminated through some discriminatory measure, which we'll be talking about in a moment. All right, so that's a good segue to start discussing Title VII. You may remember, or maybe some of you are way too young, that JFK was President of the United States. And he was very popular, very well liked. And he was assassinated in Dallas, Texas, by a guy, allegedly by at least one guy named Lee Harvey Oswald. There could have been other shooters. There's a movie about this with Kevin Costner, I believe, and I think Oliver Stone directed it. There's still a question, a conspiracy question about who killed JFK, but it's pretty clear that Lee Harvey Oswald was probably one of the people that killed him. And on television, a guy named Jack Ruby, who was a pretty well-known nightclub owner in Dallas, Texas, took it upon himself to gun down Lee Harvey Oswald in front of millions of people. And my former boss, a guy named Melvin Belli, decided to represent Jack Ruby. And he's trying to say that, you know, he was actually a public hero and he wasn't a murderer. And the case went to trial. Mr. Ruby got convicted and his case was on appeal, and I think he had a heart attack in jail. Anyhow, this is sort of the background for the launch of LBJ getting into office. And LBJ, Lyndon Baines Johnson, had this platform contract with the United States that he would start protecting people at work. Now, to me, it seems a little crazy that in the year 1963, which was only, you know, a little more than 40 or 50 years ago, that the United States Congress had to institute legislation telling employers that they shouldn't discriminate against people based on their race or other factors or other protected states. It's pretty remarkable that we had to have the government telling private sector that it's now illegal to discriminate against people based on certain factors. National origin is one. National origin, if you come from another country, you're a member of a protected class. If you're over the age of 40, you're a member of a protected class. If you are now disabled under the ADA, which was not around in 1963, it's become relevant more recently, and we'll talk about the ADA a little bit later. You can't be discriminated against based on your religion or your gender or your race. Now, those are the major protected classes. So we have national origin, age, race, gender, religion, and now disability under the ADA, which is more recent. However, religious protection is what I call semi-protected. So if you are trying to exercise your religious rights or practices, you have what I call a semi-protected status. I'll give you an example of that. Or actually a question. The question becomes, does the party's individual religious beliefs, do those religious beliefs outweigh the company's interests? And again, let me give you an example. Let's say that I go to work for Walmart. I'm applying for a job at Walmart, and I tell the hiring supervisor that I don't work on Saturdays. Right? Anybody ever seen that movie, The Big Lebowski? There's a funny line in it, and the John Goodman character says, "I don't bowl on the Sabbath." He decides to become Jewish all of a sudden, and they say, "Hey, you're not even Jewish," but he's trying to pretend like he can't work on the Sabbath. But in earnest, let's say that Saturday is really my day of rest. And I come to Walmart, and I apply for a job, and they say, "Hey, you know what, Mr. Silverman, we really respect your religious beliefs, but Saturday is our busiest day of the week. That's when we need to have people working as cashiers. We've done studies, and Saturday is overwhelmingly important to our bottom line. So if you can't work on Saturdays, I'm sorry, you're otherwise qualified to do the job, but we can't hire you. We need somebody to cover on Saturdays. Now the question becomes, can I sue under Title VII for religious discrimination? And the answer is probably no. Under those facts that I gave you, the employer's interests in having me work on Saturday, their business interests, outweigh my particular or individual religious beliefs. Give you another example. I come to work for McDonald's, and my religion, like many religions, say that men are not allowed to shave their facial hair, right? It's against that religion to shave off facial hair. And I have a pretty big beard, and I come to work for McDonald's, and they say, sorry, we can't give you a job. And I say, what are you talking about? My religion says I'm not allowed to shave my beard. This is part of my religion. I'm a holy person. Sure, I love to work at McDonald's. I love to work here, but I'm not shaving my beard. And they say, well, again, sorry, you're not getting the job unless you shave the beard. And I file a lawsuit. Am I going to win? Probably not. Why? Well, there are health and safety code issues, right? If my hair falls into a Big Mac, it's probably not going to be very healthy. I don't know, maybe it would taste better. Nothing against McDonald's, of course. But the point is that those company practices become more important by protecting the health and safety of people that are eating at McDonald's versus my interest in growing a really nice beard. Okay? So religion is a semi-protected class. Everybody get that? Now, the other classes have full protection. Full protection. And if you're discriminated against based on your protected class, then you probably have a very good claim. You have a good claim for discrimination. Now, remember that if you're considering a claim for discrimination, or your employees are, then they have to prove that there's a nexus. They have to prove that there's a relationship between the termination and the protected class. So if I'm coming to work tardy every day, and Michael, my supervisor, fires me, and I happen to be a member of a protected class, but my protection under that class has nothing to do with the fact that Michael fired me, and has everything to do with the fact that I'm tardy all the time. I'm going to lose my case, right? Because it's just coincidental I'm a member of a protected class. I have to prove that he fired me because of my protected class and not because I'm tardy all the time. There has to be a relationship between those two. Everybody understand that? Now, discrimination doesn't take place just at the termination stage. It can also take place at the hiring stage. So if I prove that I'm not getting hired for a job because I come from the Middle East, right, and I'm a member of a protected class, and I can prove that, I might have a case. Or if I'm treated differently, we call it disparate treatment. If I'm a lady and I'm getting paid less than all the men doing the exact same job, and by the way, in the year 2015, I can almost guarantee you that if you look at statistical charts put out by the Department of Labor, that women are still getting paid less than men doing the exact same job. How could that be possible in the year 2015? Women need to stand up for their rights and stop being exploited. It's crazy. Why should they get paid less when they have the exact same qualifications, if not greater qualifications, of men doing the exact same job? How is that fair? How could that possibly be fair? So there's still widespread discrimination. It may be cloaked in other ways, but in fact, if you look at the Department of Labor statistics, the percentage of people being discriminated against, and if you look at the DFEH, the Department of Fair Employment and Housing, and the EEOC, the Equal Employment Opportunities Commission, at no time are claims for discrimination going down. Now you might say, well, Mr. Silberman, maybe that's just because people are becoming more aware of their rights. Maybe there aren't as many claims because employers aren't breaching Title VII, but maybe just people are becoming more aware of what their rights are and therefore can file claims. Now, if you have an employee, right, I assume most of you are going to be employers or entrepreneurs, or maybe you're going to be employees or employers, but if you're an employer, your employee cannot file a case against you for discrimination in the Superior Court or Federal District Court until they exhaust their administrative remedies. What does that mean? They cannot file a claim, a lawsuit, until they have a claim at the EEOC and the DFEH. They must get what we call a right to sue letter. Now, after you get a right to sue letter, and if you have a lawyer representing you, you can get a right to sue letter right off the bat. But in most states, pretty much all the states in the United States, if you don't exhaust your administrative remedies, you can't file a suit. Now, why do we have this concept of exhausting administrative remedies? Well, I told you before that the courts are crowded, they're crowded like crazy. So we're hoping that the EEOC or the DFEH can resolve claims short of litigation. The DFEH is the California Consortium for Administering Claims for Discrimination. Department of Fair Employment and Housing. They also hire people that usually are a protected class, to knock on doors and try to rent an apartment and see if the landlord discriminates against them based on their race or gender. And in California, they also look at their gender preferences. Under the federal Constitution, we're growing to a status where there is protection, or there will be protection, for same-sex marriage. But right now, California does protect discrimination in the workplace against same-sex individuals or transsexuals. So, any questions about exhausting administrative remedies? You have to get that right to sue letter first from the DFEH or the EEOC. Any questions about that? Any questions about who are members of protected classes? Okay. I think we've covered independent contractor versus employee status, at-will employment, Title VII, and now I'm going to skip a little bit ahead before we talk about workers' compensation. And now I'm going to talk about sexual harassment, okay? Now, sexual harassment comes in two forms. If somebody is the victim of sexual harassment, they don't have to prove both forms. We have something called a hostile work environment or quid pro quo discrimination. A hostile work environment means a coworker is sending me filthy emails that make me feel uncomfortable. A hostile work environment can be like a case that I had not too long ago in Sacramento, where female employees were asked to do pole dances at lunchtime. That case was settled very rapidly. Disgusting behavior. Now, quid pro quo means that a supervisor or a coworker is trying to extract sexual favors in exchange for a promotion. Or conversely, they will threaten a job loss, right? You're going to lose your job if you don't meet me at a certain hotel and have sex with me. Now, a quid pro quo case, the implication is that there's a hostile work environment, right? Because if you're subjected to quid pro quo type of activity, then you also, by implication, have a hostile work environment claim. But if you simply have a hostile work environment claim, you may not have quid pro quo. Now, what is more difficult to prove, ladies and gentlemen? A quid pro quo case or a hostile work environment case?
prove?
What's more difficult to prove? Quid pro quo, right? Most of the time, supervisors aren't stupid enough to make their intent publicized to have sex with an employee in exchange for a promotion. Most of the time, they're savvy enough to do that behind closed doors. So then it becomes one person's word against another. Very difficult to prove. Very difficult to prove. I had a case once, and my client was an employee at the Lawrence Livermore Labs. I'm not going to mention her name, obviously. And she was claiming sexual harassment by one of her supervisors. Well, it turned out, at her deposition, and the court reporter was taking down everything she said, the other side asked for a break, and they came back and they had proof that my client had signed into a hotel registry with the alleged defendant. So the question becomes, why is she checking into a hotel room with him if this is some type of relationship that was unwanted by her? It didn't really sound like sexual harassment, but she claimed it was. She claimed it was. In the very beginning of the case, the lab offered me $50,000 to settle the case. They said, look, we want this lady to go away. She's a troublemaker. This was a consensual relationship. There was no sexual harassment. The case dragged on. She ended up going to another lawyer because she didn't believe me. And her case ultimately, 2 years later, settled for $50,000, right? She was lucky she got anything because she lied under oath. Now, how do you know if your clients are lying to you? How do you know? Well, you don't always. But if you're investigating sexual harassment and you're a member of an HR team, right, then you have to take these investigations very seriously. Very seriously. And here's one more reason why. In California, under sexual harassment law, if you have a supervisor sexually harassing an underling in any department, right? So it could be a supervisor in HR sexually harassing an employee in accounting. That's strict liability. Now remember, we talked about strict liability in tort law, and you don't have to prove duty or breach, you just have to prove causation and damages. So, if an employer is on the stand and I'm cross-examining them, and they say, well, Mr. Silberman, we gave that person training, that's no defense, right? It's strict liability. If I can prove that the sexual harassment took place, and if I can prove that the person who sexually harassed the other person was a supervisor, that's strict liability. My case is much easier. I just have to prove causation and damages. So obviously, the state of California, and I would suggest that many other states, take sexual harassment very seriously. Now, why do we have this carved out exception for strict liability when a supervisor is harassing an underling? Why do we have that exception? Yes, tell me your name again.
Yazdan?
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 Yazdan.
And it will be like an abuse of power.
Right. So supervisors are in a much better position, much like a common carrier, to take advantage of their. A young man who worked in a factory, and another coworker, and this guy, they were standing on an assembly line. I think they were manufacturing something, and the one guy was teasing my client and saying, you know what, you've got an ugly wife. I can't believe you got such an ugly wife. And my client was like, are you kidding me? My wife's not ugly. And they got into fisticuffs. They got into a fight. And the question became, was this a workers' comp case? Well, did the injury arise out of the employment? Yeah, it happened at work, right? It was on the assembly line. Was it caused by the employment? Or was it just coincidental? Were they just having a personal argument? Well, it turned out that they had been having these arguments over and over again, and my client had gone to HR complaining, and HR never did anything about it. So we had a pretty liberal judge actually here at the San Jose Workers' Compensation Appeals Board, and they said because your client made so many complaints, now it's work-related, because they didn't do anything about it. But if it was an isolated incident, if one person just said, hey, your girlfriend's ugly, and they smashed him in the face, then there's no benefit to the employer. So no benefit to the employer, there's no COE. Now, there's some very interesting cases in workers' compensation. It's been held under case law that even if you're at work and you get injured, you're benefiting the employer because you're taking a break. Or even if you're on a break, you're at the cafeteria on a break, and somebody slams into you with a food cart and injures you badly, well, you're still entitled to compensation because arrested employee benefits the employer. You're going to come back to work, and when you do, you're going to have a lot more energy and interest in doing your work. So that AOE COE is pretty broad. Now, the moment you detour from your job, we call this frolic and detour. The moment you take a detour from your job and you're no longer benefiting the employer, then you may not be entitled to workers' comp benefits. So I'll give you a funny story. There's a delivery driver, and he has access to his own truck, you know, like UPS drivers. It's a little bit of an off-color story, so for the faint at heart, please forgive me. But anyhow, this UPS driver decides to visit his girlfriend or his wife at home. And he's very attracted to his wife. He loves his wife. He's taking a break between deliveries of packages, and he decides to go home and have sex with his wife. Well, he has sex with his wife and has a heart attack for whatever reason, and he tries to file a workers' comp claim. So the question becomes, was he benefiting the employer when he was having sex with his wife? Well, only if they were making more employees. But probably the answer is he was engaged in what we call a frolic and detour. The minute that he pulled up to his house and had the intent to engage in sexual intercourse with his wife, then no longer was he benefiting the employer. So he couldn't file a workers' comp claim. Crazy case, another crazy case. There was a huge case. A guy won a sales vacation. He won a sales award. He's the best salesperson in the company, and they sent him to Hawaii. And part of this Hawaii excursion was a competition, a surfing competition, and everybody was expected to engage in this competition. Everybody was asked to compete, and when this one person who became the injured party decided to go surfing, he died. He hit a wave head on. He wasn't a very good surfer. He died, and the court said he's entitled to compensation because this was a benefit to the employer. It was a team-building exercise, and he was expected to be there. So you have the extremes, right? It becomes fairly liberal, but the question you ask is if somebody is an employee and they're benefiting the employer in some very tangential way, then they're probably entitled to benefits. Now, I told you before that workers' compensation is an exclusive remedy. So if somebody's injured on the job, they can't file for negligence. Do you think there might be some exceptions to that? Perry?
I used to be a waitress, so they said if you weren't wearing what you had signed off to be wearing, like the non-slip shoes, and you fall, then that's your fault.
So that's completely erroneous. They cannot sign a waiver against their liability. It's against public policy. So there's no way around the no-fault system. And I'll give you another illustration. I had a client who was told, do not come to work on Saturday. We're doing some construction work. And she said, but I got to do the end of the year books. Saturday's my last opportunity. She didn't listen. She went to work and she got injured because there were some ladders that were strewn about negligently, and she wasn't entitled to compensation. Because even though she was told not to come to work, she still benefited the employer. So that's erroneous. Here are the two ways to get around the exception of the no-fault system. One is if the employer has no workers' comp insurance. And they can be the target of significant penalties. They can probably be put out of work and out of business. So once you form your company, and after you properly form your company as an LLC or an S Corp or a C Corp, which we'll be talking about in a few more weeks, make sure you have workers' comp insurance if you have employees. Because if you don't, and you get sued by an employee, there's so many penalties and so much money to be lost that you could be driven out of business. So one way to escape this exclusive remedy and sue for negligence is if the employer has no workers' comp. The other is if you're injured by a mechanism that uses what we call a die press. A die press. And there aren't too many of them, but they used to use a lot of die press machines in manufacturing all across the United States. They're probably popular 50 to 60 years ago. And if you were injured on one of these die presses, then you could also sue for negligence. Now, don't forget that you could have two cases. So I'll give you an example. I'm driving to work this morning. I'm on the way to work to San Jose State, and somebody rear ends me, okay? And they're negligent. Well, I can file a case against the party that injured me, and I might also have a workers' comp claim. But if I get benefits under the workers' comp claim, the personal injury people might ask for a credit, or the workers' comp people could ask for a lien against whatever I get on the PI side. So what benefits will I get? If I'm truly an employee and I can prove that my case is AOE, COE, what do I get? Well, there are a few benefits I'm entitled to. There used to be more. So I get temporary disability, possibly permanent disability. I used to be able to get rehabilitation benefits, not anymore, and medical benefits. Now, the medical benefits have been reduced. I think you get like 12 visits to a chiropractor now. It used to be pretty much unlimited until you were cured from your disease. So there's a lot of controversy over these new laws. And it used to be if you couldn't return to your usual and customary work, then the workers' compensation insurance company had to retrain you. But when that movie star Arnold Schwarzenegger became governor, he terminated rehabilitation benefits. So he's acting like a major terminator. Temporary disability means you get paid for a certain amount of time until your injury becomes permanent and stationary. You're not getting worse, you're not getting better. Who decides that? Some doctor writes a report, says you're no longer entitled to temporary disability benefits. Now you're on permanent disability advances. And permanent disability, the word itself is a bit of a misnomer. You could have a 1% permanent disability. Mr. Silverman, I've got a permanent disability. How much money am I going to get? You got a 1% permanent disability. It's worth like $200. The higher your percentage of disability, the more value your case obviously has. The average case in my office was around $15,000 for a lumbar strain or a cervical strain injury. Average case. And the lawyer gets about 12% of that. Perry?
What if you're hurt on the job and you can prove like AOE or COE, but you're still able to work, but you have to like pay?
Okay, so then you haven't been injured, so there's no reason to file a claim. It's only if you've been injured. Now there's some exception.
What if you still have to go to the hospital?
Well, they'll cover your medical bill.
Oh, okay.
Yeah. Remember, they're going to cover your medical.
Okay.
But if you don't have a permanent injury, you know, I have a client who I've been working with for years, and he was injured through the federal government. He was a postal worker, and he basically lost his hand on a machine. So he can't ever work again, and he has permanent disability. He gets a check for like, $4,000 a month. Federal laws are a little bit different, but they're similar in concept. Yes?
And if it was determined that you were the person that was the negligent one while driving to work, do you get any benefits at all?
So the question becomes, if the person hit me was negligent?
No, if yourself, if you were
If I can still get workers' comp benefits, because remember, it's a no-fault system. So whether it's my fault, like Perry's talking about, she wasn't wearing the right shoes and she got injured, or whether I can't prove the employer was at fault, it doesn't matter. Negligence is not an issue. It's a no-fault system, both from the perspective of the employee and the employer. Does that make sense? Good question. Okay. We've talked about a lot of different things, and I hope I've given you some ammunition to either fight a disingenuous claim by an employee, or if you're an employee, to know how to protect your interests. Before I give you your group exercise, which I will do in a moment, does anybody have questions on any of these issues before I give you the word problem and break you up into groups? Okay. We're going to have 2 assignments today, but the first one won't take you too long. The first thing I want you to do is to come up with 5 questions that would be illegal to ask in an initial job interview. 5 questions that would be illegal to ask. You know, an obvious one would be, well, are you pregnant? You can't ask that. 5 questions that would be illegal to ask in the initial interview. Now, things change after you get hired, right? Because I might need to know Perry's birthday once I process her through HR, but I'm not allowed to ask her that when I'm initially interviewing her. Second, I'm going to write a fact pattern on the board, and I want you to argue this in your groups. And we're going to basically be breaking up by tables again. It is now 4 o'clock, or a few minutes before. We'll be back here at 4:30. We'll discuss the 5 questions. I want you to appoint a team leader for each of your groups, and also be willing to discuss this fact pattern, okay? And we can All right, so what I want you to do is take about 30 minutes, use the time for a bio break, and discuss this fact pattern with your group. And also remember those 5 questions that are illegal to ask during an interview. And I'm going to read the facts on the board so you understand it, and then I'll open it up for any questions so you're very clear. So Libby and Sammy were speaking Tagalog at work. Cal, their supervisor, told them never to speak Tagalog again. Never speak Tagalog at work again. 3 weeks later, Cal heard Libby and Sammy speaking Tagalog. 2 weeks later, they were fired. Okay, so very, very vague, very open-ended, a lot of holes here. Question? Tagalog. Tagalog.
Tagalog.
Tagalog.
Tagalog.
Tagalog. Thank you so much. They were speaking a language that emanates from the Philippines. How's that? So that's the fact pattern. Does anybody have any questions about it? What's happening here? Yes? One moment. Let me just turn this off. All right, my friends, before we talk about the group work that you did, I want to deliver you a little more curriculum, and that relates to the Americans with Disabilities Act. Now, the ADA is not part of Title VII. It was probably legislated about 20 years ago, something like that. There are certain problems with the ADA. One is that because of this law, there have been certain watchdog groups that will go around to different businesses and almost put them out of business. They'll say, oh, your ramp is not in compliance for disabled people, or your doorway is too small. Actually, Clint Eastwood had a case against him. He has a hotel in Carmel. I think it's called the Mission Ranch. And some lady sued him because she was so overweight that she couldn't get into one of the bathrooms, and claimed that he was not in compliance under the ADA. So although the spirit of the law, I think, is very good, that it protects people with disabilities, it's gone too far as the enforcement is concerned. The law says that under the ADA, employers must make reasonable accommodations for disabled people. Well, what's a reasonable accommodation? That's a question of fact. A reasonable accommodation for IBM to provide an unbelievably elegant, expensive, ergonomically correct workstation may not be feasible for a mom and pop dry cleaners or flower shop. So what's reasonable for one party may not be reasonable for someone else. Question?
Was the language so loose on purpose? Like, I'm just curious, because like reasonable doesn't really, you know, make it clear as to what.
Yeah, that's why the legislation is so vague that it's often attacked on constitutional grounds, because what is reasonable? What's reasonable for one company may not be reasonable for another. So there's tons of litigation in this area, and the legislation wasn't drafted very well. Just like the Obama plan is coming under scrutiny by Justice Scalia because some of the language in that is vague or doesn't suggest the purpose that it was initially intended for. So even though the legislation was drafted with the intent to protect disabled people, in its enforcement it's becoming very circumspect. Now, the ADA is also problematic because it's illegal to ask somebody when they apply for a job if they're disabled. So how do they get away with asking people that kind of a question without just coming out and saying it? Well, what they'll do is they'll provide a job description, right? I'll provide a job description and I'll ask Monica, now Monica, is there anything on this job description that you can't do? Are there any essential elements of this job description that you can't carry out for any reason? And then you say, well, yeah, I really can't lift more than 20 pounds. Oh, really? Why is that? Well, because I hurt my back in a prior workers' comp claim at ABC Company. So now I'm sort of getting to the information in a backdoor methodology. But the other problem with the ADA is if the employer doesn't know about the person's disability, how could they accommodate it? So it's kind of a strange paradigm, if you will, where there's a lot of secrecy and silence, and discovery has to almost be initiated by the employee. They almost have to come to the HR and say, hey, look, you know, I have X, Y, or Z disability, and in order to accommodate that, you have to do A, B, and C. Now, here's the other thing, is that with the accommodation that's being suggested, right, if Nick wants to be an airline pilot, but his optometrist says that he doesn't see very well, then he's not qualified to do that job, right? He can't meet the essential functions of that job and do it correctly. So regardless of what accommodation I can provide to a blind pilot, it's never going to be safe for him to be flying for a passenger airline. Even a cargo airline would be very, very dangerous, obviously. So there's nothing that that person can do to make his disability accommodatable, if that's a proper verb. So any questions with the ADA? Americans with Disabilities Act? Yeah, so as was pointed out, the biggest problem with the whole legislation is what is reasonable. And it creates quite a conundrum for those that are trying to interpret the law. Oh, I'll tell you one case, which was kind of interesting, and then we'll move into your group discussion. I represented a police officer who claimed he was dyslexic, and he had trouble writing reports, his day-to-day police reports. And this was up in Siskiyou County, kind of a podunk town way up north. I've never even been there. And they said it was like, okay, we're going to accommodate you by purchasing a little hand recorder so you could voice all of your police reports. You can record all of your police reports by voice. But what they didn't think of is that they had to hire somebody to transcribe those tapes. So initially they made the accommodation, but when they figured out how much it was going to cost to transcribe the tapes, they fired the guy. So it was a huge mistake by initially giving him that accommodation and then taking it away. Major, major mistake.